We are wrapping up to the spring conference with Sandi Johnson talking to us about Rule 16. It'll be awesome. Sandi.
Thanks, Bob. I'm a little disappointed I didn't get you to read a paragraph about how amazing I am.
Sandi Johnson graduated from the University of Utah Law School.
Keep going, keep going.
Well, I don't know anymore. Let's see.
Other than this is going to be an excellent presentation.
That's right.
All right.
That's right.
So my name is Sandi Johnson. I am a deputy county attorney for the Utah County Attorney's Office. Talking about Rule 16. So to start off with, we're going to go on a walk down history lane. This gentleman, and if Lance Bastian is out there, anybody who knows Lance Bastian, I could have put up a different picture and done a who does this person look like, but that's a skill he has that I do not. So this is Senator Todd Weiler, and in 2017, Senator Todd Weiler introduced Senate Joint Resolution number 7, which would amend the rules of criminal procedure to punish prosecutors for discovery violations. Now, like most legislation, you're probably wondering what many things had happened that would have caused this legislation to be necessary. Well, what he said is there is a need in the state to focus on this duty of prosecutors to disclose evidence favorable to the defendant in a timely manner. I see a raise of hands here of everybody objecting to this proposition from prosecutors, right? Like, what? We have a duty to disclose things in a timely manner? And Senator Todd Weiler cited exactly 0 evidence as to why we needed this rule of criminal procedure changed. So what happened is he then went on and talked about how, because of this rampant problem that didn't exist, for anyone to argue that we should give bad prosecutors the opportunity to go an entire year and potentially get away with knowing and willfully withholding evidence favorable to a defendant, that's a problem, he said, without any evidence. So, because we had this Senate Joint Resolution, in comes SWAP, who said, whoa, can we just slow down here a little bit? Look, I think a better idea would be let's go to the rules of criminal procedure and let's get this changed there instead of with a joint resolution. So with that agreement, they circled Senate Joint Resolution 7. And everybody in here is thinking, whew, thank goodness, right? So there is, in fact, a committee on the rules of criminal procedure. And in fact, prosecutors are on it. This is a list of the people who are currently on the rules of criminal procedure. Now, when any of you read changes in rules of evidence and rules of criminal procedure and think, what are those people thinking? By all means, please come join these committees, okay? Because this is where you make the difference. Instead of just reading about it afterwards, get on the forefront. So in this case, 2 prosecutors specifically, Jeff Gray and Ryan Stack, the rest of the attorneys, or Blake Hills as well, was prosecutors. So they went through, and in July 22nd of 2020, they published a proposed rule. And it goes out, for those of you who don't have your email updated on the Utah State Bar website, get that updated so you can get the emails. It goes out for public comment. And in this case, I have to say, well, generally, I'm very proud to be a prosecutor. But when this came out, we were amazing. All right? We got 31 comments. Now, most of the time when the rules get put out for comment, you'll get 4, 5 maybe. 31 different comments came in specifically from prosecutors about why what the committee was proposing was not such a good idea. And I've just listed the people who put in those comments from all over the state. Washington County, Uintah County, everywhere these comments came in. And I'm going to quote what Davis County submitted. They said, "We believe that we are at the forefront in the state of Utah for providing discovery in the most ethical, fair, and complete manner possible. It is in this light that we provide the following feedback on the proposed changes to Rule 16, not as an attempt to avoid complying with our obligation to provide full and meaningful discovery, but instead to demonstrate the difficulty and in some cases impossibility of complying with the proposed rule changes. In our view, many of the proposed changes make it impossible for even the best intentioned prosecutors to fully comply with the proposed rule as currently written. That was an awesome introductory paragraph, right? We didn't come out and say, you guys are dumb. We didn't come out and say, this is a terrible, terrible idea. We said, look, your idea is good and one that we as prosecutors all agree on. We want to be ethical. We want to provide everything in compliance with Rule 16, but what you're proposing is impossible in many instances. And then as prosecutors, we cited actual things like rules and case law instead of just our feelings or pounding the pulpit, right? It was fantastic. So after getting all these comments, the Rules Committee said, well, that didn't work so well. Let's take all these comments and let's go back and let's see if we can tweak everything a little bit. So they went back, and just as a premise as to what the proposed rule of Rule 16, what the goal is, this is a quote from the committee chair. Because a lot of the comments came back and said, hey, that's not what the case law says that we're obligated to do. Hey, that's not what the Constitution says we're obligated to do. But what the committee chair noted is, he said, look, we're not trying to limit Rule 16 based on interpreting constitutional provisions. The court rules can and often do impose burdens or limitations on the government, and I would add, and defense attorneys, above and beyond those required by the Constitution. The proposed changes are an attempt to secure simplicity in procedure, fairness in administration, and the elimination of unnecessary expense and delay. Now, these new rules that we went back and put together were posted on January 20th. There was very few comments. I think there was 2 or 3 that came. They weren't anything of substance. And in fact, there were a few comments thanking the committee, which is always a good idea to make sure you thank people for doing what you asked them to do. The comment period closed on March 6th, and they had a meeting on March 16th to discuss the proposed changes. So the new Rule 16 that I'm going to tell you about has not been passed yet. The old Rule 16 is still in effect. We're in this limbo period where it got sent out for comment, everything came back, the Utah Supreme Court looked at the changes that were made after all of the prosecutors' comments and said those all seem like a pretty good idea. And so now we're just waiting for the Supreme Court to approve them. So still under old Rule 16, but going to talk about what the new Rule 16 is going to do once the Supreme Court approves them. All right, so under the current rule, the focus was on discovery had to be requested by defense counsel. And it basically set a minimum that was based on the Constitution. Under the new proposed rule, there are going to be 4 categories of discovery. There's going to be mandatory disclosures, disclosures upon request, good cause disclosures, and trial disclosures. And remember, going back to the committee chairperson's focus of, we're not trying to set the bare minimum, we're trying to go above and beyond that. All right, so let's talk about mandatory disclosures. Mandatory disclosures are the very first category. And I've put up here in red where the language is going to be changing. So everything in black is what the old rule said. So under the old rule, it was material or information of which the prosecutor had knowledge. So they decided, as lawyers, we didn't have enough words there. So we added more words. Now the words say material or information directly related to the case. Right? We wanted to narrow. When we're asking for these mandatory disclosures, it can't be just, did you know something? It has to be directly related to the case, of which the prosecutor team has knowledge and control. Now, these are important additions, I believe, in order to narrow down what we are going to be required to disclose as prosecutors. Because again, these are mandatory. Defense counsel does not have to file a discovery request. Once this proposed rule goes into place, we are obligated as prosecutors to just turn this over without a request from defense counsel. So these are the things that we have to turn over that are mandatory disclosures. And again, whatever's in red is something new. So written or recorded statements of the defendant and any co-defendants and any substance of unrecorded oral statements. Reports and results of any physical or mental examination, any identification procedure, and any scientific tests or experiments. Physical and electronic evidence, right? Going back to John's earlier thing about electronic age, everything is electronic, it's no longer just physical. You know, it's now we're talking about electronic evidence, including warrants, warrant affidavits, and then also books. I've been fascinated. In 20 years of being a prosecutor, I've never actually turned over a book in discovery, but turned over journals, but never a book. Right? Papers, photographs, digital media recordings, written or recorded statements of witnesses, reports prepared by law enforcement officials, and any notes that are not incorporated into that report, right? That comes directly from case law. And evidence that must be disclosed under the United States and Utah Constitution. So I'm going to talk about a couple of these things in the mandatory disclosures. First of all, the prosecutor team, right? What is the prosecutor team? The prosecutor team is any member or group involved in the prosecution or the same investigation of the case or the defendant. And specifically, it is the prosecutor, the prosecutor's staff, or police officers or investigators. Now, this, we all know, has never changed. I mean, I've only been doing this for 20 years. I would imagine those who've been doing it longer than I have will say, this is an ongoing battle that has never ended and will never end, which is, how do you get all the stuff that law enforcement has to your files, right? And we are always surprised, and you're getting ready for trial, and you go and you meet with a detective, and you sit down, and suddenly they pull out a CD you've never seen before, or a witness statement you've never seen before. And a lot of times, I believe this comes from just not understanding technology, right? Law enforcement, I think they believe there's this magical thing that happens that as soon as they upload their report after their sergeants reviewed it, that it just flies over into our files and arrives there and announces itself to the prosecutors, and then the prosecutors know to then send it over to defense counsel. But unfortunately, none of that happens, right? They approve it, it gets uploaded into Spillman, or whatever, Versadex, whatever program that your officers use. And then it doesn't get sent over until a records person in the records department actually makes the effort to send it over. And then depending on how your agency is set up, who gets that or who doesn't get that, right? It's an ongoing problem. But it's one that we have the obligation to try to fix, that we have the obligation to know. Because you don't get to say, oh, wait a minute, I didn't know that you knew that. Because law enforcement isn't obligated. We as the prosecutors have this obligation. We as the prosecutors are in charge of this prosecution team. So the courts have specifically said the prosecutor's good faith should not have any impact on the trial court's determination of whether the prosecutor had violated his discovery duties. Right? Same, this hasn't changed, right? None of this has changed. Information known to any part of the prosecution team is charged to the prosecutor, and the prosecutor's good faith ignorance does not excuse non-disclosure. So, again, whatever you can do as prosecutors to put into place to go out and train your officers, to get procedures and processes in place to get whatever they have and provide it to us. I mean, witness statements, I think, are one of the biggest issues of witness statements. Because for whatever reason, they get uploaded differently into the Spillman program or into Versadex. And then when the records person is sending them over, they don't get sent over. And so you don't know. We need to be reviewing our files. We need to be talking with our law enforcement officers because we are now obligated to send that over. As soon as a police officer gets that witness statement, it is now a mandatory disclosure on our part, or will be once the Utah Supreme Court passes this rule. All right, knowledge and control. That's another thing that was limited, right? It has to be within the prosecutor's team has knowledge and control. So first of all, we go back to what has always been in existence, which is Pliego, right? State v. Pliego, State v. Knight. Those are going to be some pretty big cases for you as prosecutors. We cannot be expected to disclose materials that we, as the prosecutor team, not just the prosecutor team does not know exists. And we are still not required to turn over every stone or exhaustively pursue every angle, searching for exculpatory evidence or other evidence that may be helpful to the defendant's preparation of his case. It's the same obligation as before. And the control part, though, is also the part, because defense attorneys like to throw around the word government, right? Because they don't like to acknowledge that, like, we're cities and we're counties. Like, if they say the word government, then somehow we have the NSA available to us to just go find all the things in all the places everywhere, okay? But we are not. So this control part becomes important. So in State v. Pliego, that was where the defendant was trying to get the prosecution to turn over DCFS records and records from RTAC. Well, as the prosecutor, you don't have any more control over those records than the defense attorney does. Those are protected records. Those are privileged records. Those are records of the victim. There's many other things. And so if you don't have control over those records, you are not obligated to turn those over under the mandatory disclosures. You are only required to turn over what you have knowledge of and control over. And again, the quote that I think as prosecutors we have all quoted multiple times when defense counsel send us their 5-page template of all the things that they want, right? Which is, we do not have to take on that Herculean effort that you want us to do to go find all the things that you're hoping might turn up something that might possibly make your client not look like the guilty person that he is, right? All right, so mandatory disclosures. Under those, everything is pretty self-explanatory. The last thing, though, is where there's the catch-all, right? It's the Brady, and I've heard it now pronounced Giglio, I being from not where other people are from, pronounce it Giglio. But whether it's Giglio or Giglio, voir dire, voir dire. We could all have our differences here, but the Brady-Giglio provision is their last provision here. So it's talking about material evidence. I want to caution you. Material evidence and whether or not evidence is material has a different definition depending on the context that the Court of Appeals is looking at it. So when you're looking at case law and defense counsel is citing case law, find out what case that look at the facts of that case. Because if it's material in the context of discovery, there's a different definition for material evidence if it's a motion for a new trial. There's a different definition if it's for ineffective assistance of counsel. There's a different definition in when something's material for post-conviction relief filings. It's a different standard if it's a due process violation versus a Rule 16 violation. So whenever you get anything and they talk about evidence being material, it has a different meaning in different contexts. So what we're going to talk about is in the discovery context, what Rule 16 actually means. So material evidence in the context of Rule 16, I put this quote up. I don't like to put up long quotes, but Justice Marshall and Brennan, they wrote a dissent in United States v. Bagley. And I think it really sums up what we face on a daily basis. The justices said, the dual role that a prosecutor must play and the very real pressures that role create have not changed. The prosecutor surely greets the moment at which he must turn over Brady material with little enthusiasm. In perusing his files, he must take the often difficult decision as to whether evidence is favorable and must decide on which side to err when faced with doubt. In his role as an advocate, the answers are clear. In his role as representative of the state, the answers should be equally clear and often to the contrary. Evidence that is of doubtful worth in the eyes of the prosecutor could be of inestimable value to the defense and might make the difference to the trier of fact, right? Ultimately, our job is interest of justice. Our job is truth. But it really does become that difficult. And I would say it's not necessarily difficult about turning over the evidence. It's that we know we're going to turn it over, and we have no problem turning it over. It's just that we know the second we turn it over, defense counsel is going to accuse us of being unethical. They're going to accuse us of giving them something at the very last minute. They can't possibly prepare a 3-sentence witness statement for trial in a week, that they're going to need a continuance. Like that, I think, really becomes where our hesitation is. It's not, should we turn it over? It is, crap, this is going to get me a continuance now. This is going to get me a motion now. Because I think Justice Brennan and Marshall are correct, is that it's equally clear to us as prosecutors we should be turning this over. And at the end, Justices Marshall and Brennan said, it's easy and it's straightforward, a prosecutor's duty. You must divulge all evidence that reasonably appears favorable to the defendant, erring on the side of disclosure. So what is the definition of material evidence? It's anything that's exculpatory, it's anything that's impeaching, and it's anything that has a reasonably probable that disclosure would affect the outcome of the criminal proceeding. That last definition is really, really tight, right? We can all interpret that. There's only one meaning for that, okay? So when you're talking about what will affect the trial, not necessarily impeachment. Impeachment, I think, is easy, right? Inconsistent statements, things like that. That's pretty easy impeachment convictions. When the reliability of a given witness may well be determinative of guilt or innocence, non-disclosure of evidence affecting credibility falls within the general rule of Brady. So when it comes down to credibility, if there's anything that affects credibility, it falls under that catch-all provision. And again, you don't have to go out and search for exculpatory evidence. So those are the mandatory disclosures, right? Brady and Giglio materials, the list that's pretty self-explanatory on the list, but those mandatory disclosures are limited to the prosecutor team that's related specifically to that case over which you have knowledge and control. So now we're going to move to the hard parts. Disclosures upon request. Now, this part, I apologize to everybody out there who is a city prosecutor, who represents an agency, or who knows anything about the dreaded word grandma. Because what I'm about to say is probably going to butcher everything involving grandma and is going to make you cringe. Because I'm a prosecutor and I hate that stuff. That's why I call you. But I'm going to try to do my best to give a summary to all the prosecutors out there that disclosures upon request, this category is specifically grandma. So for the disclosures upon request, the record must be in a mandatory disclosure list, right? So the defense counsel doesn't get up and say, I request this, and I want you to go out and get something from 7-Eleven. All right, not going to, because it's not in the mandatory disclosure list. The mandatory disclosure list is, all of the stuff. The record must be possessed by another governmental agency. Again, 7-Eleven, not a governmental agency. The record must be one that can be shared with the prosecutor under grandma. The defendant's request must identify with particularity the record they are seeking. The defendant's request must identify with particularity the agency that has the record. And the defendant must demonstrate that the information in the record is directly related to the case. Now, I underlined with particularity because that's a word I like to throw around, right? It's found in Rule 12 when it comes down to motions. It's one of my pet peeves, right? Identifying the Constitution is not identifying anything with particularity. Identifying the Fourth Amendment is not anything with particularity. If it took me an entire semester of law school to learn that I don't know anything about the Fourth Amendment, then that is not identifying anything with particularity. And in fact, I looked it up online to find out what the definition of particularity is. I did not use Urban Dictionary because in my line of work, you don't Google anything on Urban Dictionary from your work. Apparently, John has a much more liberal firewall than anywhere else, right? And yes, to all prosecutors, be cautious when Googling anything on Urban Dictionary. All right, so particularity means small details, minuteness of detail in the treatment of something. So what this really comes down to is you don't get to go fishing with this request. You don't get to come in and say, I request anything in any governmental agency's files that might help my client. Nope. Okay, with particularity. Now, what a judge will define as what particularity means is always the hurdle that you have to get to. But as prosecutors, you can always respond, that's not with particularity. All right, so I want to talk about, again, record must be in the mandatory disclosure list. Going back, what the disclosure list is, it's got to be, statements of the defendant or co-defendants, records of results of physical examinations and testing, reports prepared by law enforcement officers. So these are the most common records that, in my experience, we've been requested to get, right? Utah Office for Victims of Crime, UOVC, restitution, okay, DCFS, other law enforcement agency reports. I want West Valley's police report, even though this case was investigated by the sheriff. Okay, the Bureau of Forensic Services, right? Your tool marks, drug testing, DNA testing, all of those. Utah Public Health Laboratory, your toxicology, the medical examiner reports. Now, if you look at those lists, in DCFS, is it going to have written or recorded statements of the defendant, right? So before you go anywhere, when defense counsel's asking you for a record under this disclosure, you have to ask yourself, is what they're asking for, does it contain what's in that list? If it's, I want a statement of the victim, okay, well, that would be a written or recorded statement of a witness. Okay, so they've met the first hurdle. If it's, I want the victim's mental health records, all right, is that a result of any physical or mental examination? Arguable, right? But they've got to tie it back. It has to be on this list. My favorite, and the one I kept fighting with the committee about, was search warrants and affidavits, right? As a prosecutor, I don't have any more access to search warrants and affidavits than the defense attorney does, because those are maintained by the courts, right? It's filed with UCGIS. It's uploaded to UCGIS. If I want to get a copy, I have to go to the court and ask for it. But what Rule 16 will be saying now is, hey, prosecutor, mandatory disclosure, you go get it from the courts if you didn't already get it from your law enforcement. Okay, so there are 4 categories of records. This is, again, I apologize to all the grandma experts out there. Public records, which are search warrants, arrest warrants. Private records is a category. This includes body-worn cameras, recordings, prosecutor and law enforcement personal information, sex offender registry documents. Protected records is the most often requested category, most likely. It includes, again, DOPL records, UOVC records, records maintained and created for criminal purposes. And then you've got controlled records, which are medical, psychiatric, psychological data. So what happens is defense counsel would always come in and say, hey, prosecutor, you're government. You go get these records. They're in another government's possession. You go get these. All right, so let's talk about what's called the sharing provision. The sharing provision is under 63G2, 206. A governmental entity may, notice I underlined the word may. Okay, as prosecutors, we don't get to tell anybody what to do. If you are representing an agency as the civil attorney who does your grammar requests, you in fact may get to tell your agency what to do. But as prosecutors, in that capacity, we don't get to tell an agency that we do not control what to do. So they may provide a record that is private, controlled, or protected to another governmental entity that enforces, litigates, or investigates criminal law proceedings, or one that collects information for pre-sentence reports, probationary, or parole purposes. So essentially prosecutors and APMP. So in order to get that by rule, under the sharing provision, you have to make a written request. It can't just be calling somebody up and say, hey, can you send me over those crime lab reports? No, they have to have it as a written request. And a subpoena or a other method of discovery is not considered a written request for purposes of grandma. So you can send them a subpoena all you want, and they're going to respond back and say, send me a grandma request. Okay, so send them a grandma request. Now, as the prosecutor, defense counsel is going to file a motion under this request for disclosure. They're going to say, Sandy, I want the full file from this toxicology report, because despite the fact that it shows that my client had methamphetamine and alcohol in her blood, I think there was an error with the testing, and if you send me the whole thing, I'm going to look at it, not understand anything, but I can go tell my client that there's a possibility that somewhere in all those records there's an error, okay? And you are going to want to turn around and say, oh yeah, let me just call up the crime lab. Hey, we just sent me your full file. Oh, no, you cannot do that, okay? But your first response is, when defense counsel asks for that request, you have 3 options, okay? The first option is you say no. You can just say, I'm not going to request it, and you list the reason why, right? Look, what you're requesting isn't related to this case. Okay, that's a blood test that was done on another case. It's a blood test that was done 3 months prior to this case that we're talking about, so I don't care about it. It's not related to this case. that you can say they didn't identify with particularity. They just said any blood test taken anywhere and tested at any place. You can say, nope, that's not sufficient. I'm not going to respond to that. You can say, look, I'm prohibited from getting it and giving it to you. So no, I'm not going to go request it on your behalf with a grandma request. Or you can actually request it. Now, if you request it, the agency can still refuse to give it to you. And let me give you an example of when they would do that. Because as prosecutors, sometimes we get a little lazy and we don't exactly redact things that we're supposed to redact. So we request, for example, we want records from the Utah Office for Victims of Crime because our victims are requesting restitution for mental health treatments. So we request the records from the Utah Office of Victims of Crime, and then we get it. And then what do? We're like, oh, we should just turn it over. So we turn it over to defense counsel. And sometimes we miss redacting, and sometimes we don't redact the personal identifying information. Sometimes we don't redact the actual mental health records of our victim before we turn it over. And because the Utah Office for Victims of Crime, as their name would show, is dedicated to victims, they don't care about our convenience, right? They care about protecting victims' privacy. And they have been burned too many times where a prosecutor has just gotten the file and just turned it over to defense counsel. And then defense counsel just turns it over to the defendant. You could imagine why a rape victim might not want their perpetrator to have their personal identifying information or their mental health records or other things like that about how they're being treated and who's treating them. So UOVC can say, no, I will only provide this in a redacted form, or I will only provide this with an order from the judge saying that you can't give it to the defendant. They can put those restrictions on it. Or they can just flat out say, no, we're not going to provide it, right? If they have the reasons under grandma to not provide it. So what your actions as the prosecutor, right? You have to decide, what are you going to do? Are you going to not request it? You're going to say it wasn't enough? Are you going to say, look, I can't by law? You're going to say, hey, they won't give it to me. Or are you going to go get it? So the prosecutor, if you decide you're not going to request it, or if you decide that you're prohibited by law, you have to file a notice back telling the defense attorney why you're not going to. And at that point, the defense themselves can seek a subpoena, or they can go to the court and file a motion. Or if you receive the record, you can then disseminate it in accordance with grandma. So again, going back to the sharing provision, right? Any governmental agency can share it with another governmental agency if they so choose. But under that sharing provision, any document, any record that we get, we are subject to the same restrictions as the person who originally had it. So if UOVC can't give it to defense counsel unredacted, neither can you if you got it under the sharing provision. Same goes for a crime lab report, same go for SANE exams. Okay, anything that you got under the sharing provision, if they couldn't give it to the defense, neither can you. That's a grandma violation. Okay? And you have to be careful about this. So for example, crime lab reports, the first 3 pages, and I say 3 because that's usually what I get them in, where it just lists, say, the person's either DNA results or it'll list the blood alcohol level, right? So just the basic, this is what the person's blood tested at. Those are considered the police agency's record. So the police agency that's why they can share it with you and you can share it with defense counsel. But anything else that might be in there, again, it might contain protected records. It might also contain private records. So again, I want you to think about, for those who do sexual assault cases, victim goes and gets a Code R exam done. There's a medical health professional there who takes a record and makes a record and a report. And then they include that in the same kit, in the Code R kit that goes up to the crime lab. The crime lab then takes that report. It guides them on which samples they're in fact going to test. They then test those samples. So contained within the records of the crime lab who was doing the DNA testing, you actually have the protected records, which is just the outcome, which can be shared with law enforcement. You also have a protected medical record that is the victim's medical record. So they can't disclose a private protected medical record. They can't provide that to you, and you can't provide that to defense. So you have to be careful about what you're asking for, right? So I bet you any of you have tried this, have been met with success, right? Hey, judge, look, the agency said that they didn't want to turn it over. And you got the response where the judge said, but I ordered this turned over. And you're like, I know, but there be rules, right? And so what you say, hey, judge, look, under grandma, including with the sharing provision, the records are privileged from discovery. So no matter how many times you sign that discovery order, it doesn't trump grandma. Because grandma specifically says these records are privileged from discovery. It also says that you can't disclose it until you, judge, make some findings. And again, sometimes it's a little hard to get a judge to make a finding, right? They wish that they could make those findings, but they just don't want to. So before a judge can order this to be released, so even if you have it, right? I went to the crime lab. They were great. They turned everything over to me, judge. So now I have it. But guess what? I still can't give it to defense counsel until you make some findings of what I can turn over. So the court has to sign an order. And the court has to have reviewed, first of all, the court has to make a determination they have jurisdiction. The court has to have considered the merits of the request to access that record. The court has to consider and, where appropriate, limit their use of the further disclosure of that record. And the court has to find that the interests favoring access are greater than or equal to the interests favoring restriction. So again, this comes down to the judge is going to have to make some findings. So even if you go out and get it under your grandma request, and even if the agency shares it with you under the sharing provision, you can't then just go around and turn it over to defense counsel. You have to go back to the court. You have to get the court to make an order. You have to have the court consider that disclosing this unredacted, right? If you want anything other than what the agency provided to you, you have to go get additional findings from the judge before you can disclose it further. So what this means is, if you're going to go ask for something from an agency and you know you're going to be turning it over to defense under grandma, I would be asking them and telling them specifically, I'm requesting this on behalf of defense counsel. Please only provide to me what you would disclose to them if they provided you a grandma request. Because I don't want to go through all this. This is a pain in the butt. This requires me to do another hearing. This requires me to get a judge to make findings. This requires me to listen to defense counsel talk about how I'm trying to hide stuff. Okay, and I don't want to do that because it exhausts me. So I'm going to ask the agency and say, just turn over what you would give defense. Right? But a few additional thoughts. We've already talked about that. If a lot of times these records are coming from an agency that is represented by an attorney. Okay, UOVC has an attorney. The crime lab, they have an attorney general who represents the crime lab. DCFS, they have attorney generals that represent DCFS. If you're going to have the judge order DCFS to do something, you need to make sure that their attorney is notified about that hearing, because you don't represent DCFS, you don't represent the crime lab, you don't get to speak on behalf of them, so make sure that their attorney's been notified. And there may be additional rules to grandma, right? Just because I get medical records, for example, doesn't mean I get to turn them over, because I also have Rule 14, which says if it governs anything involving a subpoena or a court order, which would be a discovery order, right? A court order for medical, mental health, school, or other privileged records of a victim. So just because I can go get those doesn't mean Rule 14 doesn't apply. It means, okay, I have them, but now we still have to go through a Rule 14 in-camera review and have the judge make all those findings. Okay, so that is the disclosures upon request. Again, it all has to do with grandma. Okay, we'll talk about good cause disclosures. Good cause disclosures it's the same language as before. This hasn't changed. So just a couple of highlights for this. We believe that Rule 16 should be liberally interpreted within the confines of the requirement's purpose. In other words, good cause should be liberally interpreted. It does require a preliminary showing that the evidence is necessary to properly present things at trial. And this right here is just my baseline. I always file a motion for state's discovery, and I list this because this was out of State v. Spry. This is exactly what the prosecution sought in that. And the court in State v. Spry specifically said all of the state's requested disclosures were material as they involved information on witnesses and documents which the defendant intended to use at trial. So if you stick with this on your state's disclosure, great. If you want anything more than this, then you need to make sure you make a preliminary showing about why you need it. And I find that using and listening to defense counsel is always good practice. Because whatever they say about why they need something from me, I'm going to write that down. So later when I ask for it from them, I'm like, Judge, remember how they said it's necessary? Yeah, it is. I agree. Okay. But if you're going to object to defense counsel, you better make sure you're not going to then turn around and ask for it either. Okay. So just think about what it is for a good cause. All right. Trial disclosures. Trial disclosures now are what's required. This is our fourth category, trial disclosures. A written list of the names and current contact information of all persons that you intend to call at trial. Any exhibits that you intend to introduce at trial. Upon order of the court. Now, this was a big one that we also fought about because the committee originally wanted us to turn over criminal histories. Well, under the statute, we can't, right? It has to be by a court order. So upon order of the court, we turn over criminal records of any persons that we intend to call at trial. These are just the rules that talk about why we can't just turn them over just because we have access to them. We have to have a court order. The only sort of exception to that is the defendant's criminal history, but even the defendant's criminal history under the statute has to be done only upon request. So this will get a little bit tricky if defense counsel stops just filing their boilerplate request for discovery. Before you send over the defendant's criminal history, you might just need to send a quick email that says, hey, do you want this? And they'll say, yes, I request it. And you say, okay, great, thanks. Now I can send it. All right, information not subject to disclosure. This is attorney work product, essentially. This hasn't changed. The only thing that they just noted was that the exception under Rule 25b-5 of the Rules of Civil Procedure does not apply in criminal cases. So they clarified you don't get to take Rule 26 from the civil procedure. All right, timing. When are we required to make these? As the prosecutor on the mandatory, as soon as we know about it. As soon as we can after we file charges. And as long as we've got it before the preliminary hearing, before the defendant enters a guilty plea, or before trial, unless they waive that. And this was a big thing, especially in justice courts, right? Where a lot of times defendants come in and they're entering pleas without even getting copies of the police report. That's where you just need to make sure that they waive. Hey, I've got the police report. Do you want it? If you don't want it, I just need you to waive the fact that I'm not providing it to you before you enter your plea. All right, upon request, the whole grandma stuff, there's no timing. For good cause, again, no timing specified. And the trial disclosures have to be made no later than 14 days prior to trial or as soon as practicable. And just as a practice pointer, again, as prosecutors, I encourage you to ask for deadlines, right? Deadlines are always prosecutors' friends a lot more than they are our enemy. Because again, hey judge, I want trial disclosures. I'm asking that all trial disclosures be ordered 30 days prior to trial. This 14 days stuff is crap, right? Like, I'd like it more than two weeks. And I am willing to take that on, and I want you to order defense counsel to do the same thing. Because I want their witness list 30 days ahead of time, not 14 days. And in terms of prosecutors' disclosures of timing, anything that deals with factual innocence, you always have the constitutional obligation to disclose that before plea bargaining. That's just easy. When in doubt, disclose that you're not going to disclose. So for example, unfortunately, like if victim's mom came in and brings me all of her daughter's mental health records, and she's like, here, Sandy, I want you to have all my daughter's mental health records. And I'm like, oh crap, right? Usually they give them to the officer, and the officer's like, here, Sandy. I'm like, okay, now it's in the possession of the prosecution team. I just file a discovery response and I say, look, I got them and I ain't going to give them. And if you want them, file a motion, right? Because then it's just clear. I'm not trying to hide anything. I've disclosed I have them. I've disclosed it by law. I don't have to turn them over. And if you want to argue about it, let's do it in front of a judge. All right, defense disclosures. There actually is a specific section in the upcoming proposed rule about defense disclosures. Mandatory. They're mandatory disclosures. Alibi. Right? Alibi is in statute, and It's 10 days before trial, which again, whoever wrote this statute just drives me crazy. Really? 10 days before trial, suddenly you're providing me an alibi. Unless otherwise ordered. So again, going back to his prosecutors, ask the judge for deadlines. The judge can literally tell the defendant, you have to disclose any alibi witnesses 30 days ahead of trial. Okay? Again, the statute is the baseline. It is the bare minimum that they have to provide, which is 14 days before trial, or 10 days before trial. So ask for that sooner. Failure for them to comply with that means you can exclude their witnesses, but you can never exclude the defendant from taking the stand and providing his own alibi. That the timing just won't apply to him. Insanity disclosures, again, this is a ridiculous timing period, but it's following the statute, which is no less than 30 days before trial. Because insanity, as we all know, you can get the defendant examined for insanity and an expert ready to come testify, and all of that done in less than 30 days. All right, good cause. Same exact language. Defense counsel, for their disclosures, they have mandatory disclosures. They don't have discovery upon requests, but they do have good cause disclosures. Any item of evidence which the court determines on good cause should be made available to the prosecutor in order for the prosecutor to adequately prepare the prosecutor's case for trial. It is the same as the prosecutor's good cause standard. That's right, I said it. It's the exact same good cause standard for the prosecution as it is for the defense. Right? And the Utah court has specifically said the good standard of good cause required of one is the standard of good cause required of the other. So when defense counsel gets up and says, Judge, I need to know all of their witnesses and what they're going to say because that's the only way I can adequately prepare for trial. All right, Judge, I want a list of all of their witnesses and what all their witnesses are going to say because that's what I need to adequately prepare for trial. And when they say, work product and all that other crap, then you quote this and says, Judge, good cause is good cause. Again, we don't have separate rule books. Okay, they also have the same exact thing on their trial disclosures, right? A written list of the names and contact information, any exhibits they intend to introduce, no later than 14 days prior to trial or as soon as practicable. They also have the same what's not disclosed, what shouldn't be disclosed exception under Rule 26. So this is where I'm going to just do a little quick caveat. All right, information not subject to disclosure. We need to be very careful about what words we use because attorney-client privilege is not the same thing as work products. They have different standards. They have different things of what we can get. You need to be really clear because everybody comes in and talks about the work product privilege. And then they say it's the attorney-client work product privilege. I'm like, well, that's like 3 different things you just said all in one sentence. All right, let's parse this out. What is this actually? So attorney-client privilege comes, these are really small, comes from the rules of evidence, right? Privilege comes from rule of evidence. Work product comes from the rule of civil procedure. Under the attorney-client privilege, it has to be a communication, and it has to be between the client, i.e. the defendant, and the defense attorney. Those are the only 2 people that can participate in anything that is covered by the attorney-client privilege. Under the work product privilege, it can be anything. It can be documents, it can be tangible things, and it has to be prepared in anticipation of litigation. And there's 2 different types of work product. There's core work product, which is the defendant's attorney's legal theories, opinions, and things like that. That has basically absolute protection. Like, we're never going to get that. They don't ever have to turn that over. But factual work product can be waived. Now, not every communication between an attorney and a client falls within the attorney-client privilege. And this is where I want to emphasize the difference. Because the attorney-client privilege, which is a privilege from the rules of evidence, does not include information that an attorney secures from a witness while acting as an attorney in anticipation of litigation. Okay, that comes from the United States Supreme Court. So when they go out and they interview all the witnesses that they're going to call, whatever they talk to that witness about is not covered by the attorney-client privilege. It's covered by the work product privilege, but not the attorney-client privilege. And there is a much lower bar for the attorney-client privilege, or sorry, for the work product privilege. So when they ask you for notes and things about interviews with witnesses, keep in mind, complying with the court order disclosing factual information. So your witness said, this is what happened. That does not constitute a waiver about your thoughts. So if you're taking notes, or your law enforcement officer is taking notes, or whoever it is that's taking notes, if they are interspersing, hey, this is what happened, and boy, I think this might be a really good trial strategy. I should really focus on this. Okay, you don't have to disclose the second one, but you might have to disclose the first one, even if they're in the same piece of paper. In this case, and I love this case, especially as a prosecutor, and I know this was John's case, I believe, because he sent around a bunch of sample memos. State v. Stephan, right, from last year, John? Right? The district court found that the state had shown good cause for Stephan to disclose investigator reports, investigator notes, and investigator recordings from witness interviews with both the state and defense witnesses. So all the time, defense counsel will say, well, no, because that's work product. That's work product. I don't have to turn that over. Actually, they do, okay? Because, first of all, it's fact work product. It's not opinion core work product. And what the court held was that this would be waived if the defendant intended to use those notes to impeach the witnesses on cross-examination, or if you were going to call those witnesses and place their credibility at issue. As soon as the defense attorney decides they're going to call those witnesses, then whatever facts those witnesses have disclosed, they've essentially waived their work product privilege. What Stephan did say is, with respect to notes from the interviews with defense witnesses, the district court ordered Stephan to disclose only those portions that contained prior witness statements. They didn't have to disclose their core opinion. So when defense counsel again comes in and says, but judge, then they're going to know my thoughts and my opinions. Okay, we'll redact that, but anything that's factual, you have to turn over. And you want to make sure you're narrowly construing it, right? Where Stephan, in the case of State v. Stephan, where the prosecutor and the judge ran into a little bit of problem, was the judge just ordered, well, turn over the notes, and the judge didn't make clear, okay, only turn over the notes that had factual work product as opposed to opinion work product. So just make sure the order says to turn over any factual statements made by witnesses, and that make it clear you're not going after core opinion work products. All right, methods of disclosure. It hasn't changed, right? It's all still going to be the same. You notify, you can either do it by turning it over, or you can tell them they can come inspect it, they can come copy it at specified times and places. This part is new. If the prosecutor, because they just basically wanted to make it clear to the judges. The judges have always been able to do this, but this was added to be really clear. If the prosecutor concludes that the disclosure is prohibited by law, or that the disclosure would endanger any person or interfere with an ongoing investigation, the prosecutor can file a notice saying, I'm not going to turn it over. This is why I'm withholding it. And if the disclosure by the defense attorney, if they say, but I still want it, then the court has to hold an in-camera review. You don't have to just turn it over to defense counsel to argue about it. It becomes an in-camera review. And the court will then decide whether disclosure is required and what limitations or restrictions that the judge wants to put on it. All right, restrictions for disclosure, again, hasn't changed. You can restrict disclosure based on protecting victims from harassment, from abuse, from the undue invasion of privacy. This is a big one, victim cell phones. This is a huge issue for me. Law enforcement and everybody, they just come in and they just, Cellbrite is only designed that you plug the phone in and you push a button and it just dumps the whole victim's phone. Okay, all we're looking for were the text messages sent between the suspect and the victim for like the 3 days that they met between when they liked each other on Tinder and they met up, right? Like, it's a 3-day window. Why are we downloading the victim's entire cell phone and turning that over to defense counsel? Okay, none of that is relevant to the case. None of that is pertinent to the case. That is an undue invasion of privacy. So in that case, limit what you're disseminating, limit what your disclosure is, because you're protecting the victim's privacy. Restrictions. The court can order that discovery be denied, restricted, deferred. Limitations can be modified, or any other order is appropriate, including you can't give it to your client. Okay, that is actually something that you can order. You can make this showing ex parte. So again, you can go make this showing to the judge and not have the defense attorney there or the defendant there in order for that in-camera review. All right, if you fail to disclose, again, we can't do anything that's unconstitutional, but the court can order or permit discovery. The court can grant a continuance. The court can prohibit you from introducing anything you didn't turn over or any other order it deems just. And then this is the new one, which goes back to the very beginning of Senator Weiler, which is if after a hearing, the court finds that a party has knowingly and willfully failed to comply with an order of the court compelling disclosure, the non-disclosing party or attorney may be held in contempt of court. Now, I actually had this in one of my cases where the defense attorney stood up and said, yeah, Judge, I know you ordered me to turn it over, but I chose not to. Okay, well, that's willingly and knowingly. Now, of course, the judge just excluded the evidence. It didn't hold the attorney in contempt, but. All right, the additional requirements, again, nothing about this has changed. The only thing they did was they added the language upon good cause. So you can't just ask the defendant to go speak for identification unless you got a good reason for it. My favor is I just barely filed a motion a couple of months ago asking the defendant to come get inspected to see if he was circumcised. Judge granted the motion, except for the defendant decided he didn't really want to do that, so he just stipulated. All right, additional requirements. Again, there hasn't been anything really changed. You have to give reasonable notice to the defense attorney. You have to give reasonable notice to the defendant. And if they fail to comply, just like before, you can revoke their pretrial. You can revoke their pretrial release. You could offer that as evidence of, hey, we tried to get this and he refused to do it, or any further sanctions. All right, that's it. Thanks.
Okay, thanks everybody for coming. Thanks to all those that stuck around online. We look forward to next spring when we can fill the room. So go forth and conquer. Thanks.